full council, yes.
We might bump up
Right now.
Recording in progress.
I think that's a great idea.
Ready?
I do?
Because nothing gets done.
Yep, I'm ready. Ready?
Good afternoon, everybody. We'll call the Protection Policy Committee meeting for Monday, July 24th at 5 p.m. Roll call. Morgan. Present. Alder Grant.
Present.
Randy.
Here.
Stevens here as well. Take a motion to approval of the agenda.
So moved.
Do I have a second?
Second.
All in favor?
Aye.
All right, on to regular business.
Minutes.
I will take a motion.
Minutes.
Oh, minutes, sorry. Approval of the minutes.
I move to approve those minutes.
Second.
Second.
All in favor?
Aye.
All right, on to regular business.
I make a motion to suspend the rules
For 1 through 5.
for 1 through 5. Yeah.
Do I have a
Take a
second?
Second.
All in favor?
Aye.
Any questions? No? No comment?
From 1 to 5. No objections.
Staff?
No, nothing from us.
Okay, thank you.
Motion to approve.
All right, do I have a second?
Second.
All in favor?
Aye.
Nays? All right, ayes have it. On to number 6, consideration of possible action on general ordinance number 4-23 and ordinance creating section 10-95 Green Bay Municipal Code related to massage establishments. Attorney?
We're taking a switch.
Thank you, Alders. So this was referred back to staff last time, and there were a couple of items that were highlighted, and so I'll address those changes that we went through. First, we did look into whether or not massage therapy should be allowed in residentially zoned areas. It is going to be allowed, and that'll be consistent with our zoning code as well. So we made sure that those, there's no concern there. In order to make sure that we're consistent with the zoning code, we did have to update the hours of operation. So that would have been updated to 7 a.m. to 9 p.m. So not too much of a deviation, but just making sure that we're consistent across the zoning code. We removed the section about light so that it allowed for light therapy. So that was an item that we were asked to look into, and so that's been removed. And finally, the last part was a waiting area. That section has been left in, most notably to safety concerns, to ensure the safety of individuals, massage therapists themselves, as well as city staff, including PD as well for emergencies. So having that area is important to protect the health and safety and welfare of the public. So those were the 4 items that was identified to take a look into for more research, and so that has been updated accordingly. Those are my notable updates. So they're included in the red line, is underlined and voted. So,
Thank you.
updates for that.
Any questions? Alder Grant?
Just for clarification on the waiting, excuse me, area, it does not have to be a waiting room, a hall would suffice, correct? Or separate space from just,
Yep, and as long as that space has access to the entrance, because that's in addition to what's important about that waiting area as well, making sure that this area is safe and has proper emergency routes to go to. What we don't want is just a single room, so that's limited to only that. We want to make sure that everyone is protected and can feel safe in these areas.
thank you.
Any other questions?
Good job.
Thank you.
Alder Grant?
Okay.
Alder Eck, sorry.
Under K, Section 3, effective date, I would like to propose to amend that to December 1st instead of May of 2024. Councilmember West.
Yep. And if I may speak on that, part of that is a balancing act, which is ensuring that, the importance of this ordinance, as well as balancing the time that the individuals who need to comply with this license may need in order to come to compliance, as well as making sure that city staff has enough time to make sure that they're properly trained on this. So that's part of the reason why it was in there. If we want to make changes to that daytime, the start time, effective date, we certainly can do that. But those are the considerations that we're looking at when we reach that conclusion about that date.
Well, let's hear if the public has anything to say about that, and otherwise, I think the sooner we can get going on it, the better. But maybe, for the reasons stated, it might be better to wait a few more months if the industry would like that kind of time.
Okay, motion open the floor.
Motion to open the floor.
All in favor?
Aye.
Nays? All right, ayes have it. Who would like to speak first? Anyone? Okay.
Jamie
So-
Emer,
one
14.
moment.
Oh, sorry.
So anybody that wants to speak this evening, you'll be limited to 3 minutes, and you have one time to speak only. Okay. And if I could have your name and your address.
Jamie Emer, 1422 14th Avenue. I am a licensed massage therapist through the state of Wisconsin. I was at the last meeting. I do have a lot of concerns in regards to this ordinance that you are trying to create. As per the state statutes, it clearly states that you cannot create a ordinance onto the massage therapist if they are licensed. We're just asking that you exempt licensed massage therapists from this. When looking at your massage establishments, you talk about intimate areas, including breast, buttocks, anus, groin, scrotum, penis, vagina, and pubic mound, Buttock massage, also known as glute massage, is absolutely within the scope of practice of the state of Wisconsin, as is breast massage and working on the adductor muscles, which could potentially be considered the groin. So all three of those are already within our scope of practice. So taking those out of our ability to do in the city would potentially harm people who are trying to get sciatic work, piriformis syndrome. There's a lot of different dysfunctions that can occur with that. Also, respectfully, we're just asking that if, it seems as if it is over-regulation, considering the state does already regulate us. There are license lookup. We have to have our license already established. We also have a very extensive education process. I know at the last meeting, and I believe in some of the media, there was kind of a comparison to a liquor license. However, a liquor license does not need at least 600 hours of education. We have to have CPR certification. We need to have malpractice insurance. We need to take a national exam. We also have to take an exam on the state statutes. And then once we are licensed, we need to get 24 hours of continuing ed every 2 years. I feel disrespected in the sense that I feel like you are lumping licensed massage therapists who are part of the healthcare system. We're able to take the HSA accounts, we're able to bill insurance, and you're lumping us with sex workers. And it feels a gross injustice to our profession when we are not doing anything wrong. There are no licensed massage therapists who are creating this issue, and yet we're the ones that are kind of being targeted, because we're the ones that are going to be actually following this law, not the ones that are not practicing. So the other municipalities in the area that do have massage ordinances, all of them do exclude licensed massage therapists, because again, we're already being regulated by the state. The state does a very good job of handling all of that. So to create not only a burden in the sense of someone who only has a massage room and now needs a waiting room as well, how do they get out of their lease by the time either December or May comes, whichever one comes first? They also, I know last time it was kind of spitballed that maybe this was going to be $100 a year. Our state license is $65 every 2 years. So thank you for letting me speak.
All right, thank you. Anybody else like to make a comment?
Do you want me to check in Zoom? Would anyone in Zoom like to speak on this item? If there's anyone in Zoom who'd like to speak on the general ordinance regarding massage spas, if you would unmute yourself. No.
I would like to speak. Misty Doreen, I rent at 1270 Main Street at Class Management. I would just like to encourage you to educate yourselves a little bit further on what massage is and what it does. I understand that what we're looking for is a solution to the illicit massage in the area. However, anyone that's state licensed, we're already being regulated, like Jamie said. This is going to directly affect how we are able to do our job. And I would like each of you to think about maybe getting a professional massage just so that you have a better understanding. I will personally offer each of you a free 30-minute session so that you know what massage does and you can experience it for yourself before we make ordinances on things that you're maybe not 100% clear on before an ordinance gets put in place to affect all of us and what we do. Because personally, if this ordinance goes into place, I will move my practice out of Green Bay. And I think a lot of other therapists are feeling the same way. And that's all.
Codell Story, 415 South Davis in Iron Mountain, Michigan. But I'm a dual practicing massage therapist. What I would like to talk about is the intimate areas of the glutes and the intimate areas like that. But I work on a lot of athletes. So we have to, if they have, let's just say sciatica or piriformis syndrome, or the deep six muscles that are in the glutes that you guys consider buttocks. Those muscles need to be worked for, especially even athletes in this area. They need to be worked because sometimes those muscles get tight. Just like she said, I would rather you guys educate yourself and also get a professional massage by a licensed massage therapist before you start knocking out these things and messing it up for everyone else. Because if so, then yeah, I'll just let my license lapse because I work with a lot of athletes in this area. A lot of athletes are up in Michigan, so I don't. That's all I have to say about that. So, thank you guys for your time.
Anybody else?
Hi, Leah Waker with Military Avenue Business District. I'm probably one of the people that helped push this forward, and it is to try to get rid of the bad actors. In reference to intimate parts, that is a definition in the ordinance, and it doesn't require or say anything about, other than you as a massage therapist cannot expose those areas to your clients. It doesn't talk about actual massage. So the whole ordinance is about regulating establishments, not people. The state regulates the people, and the city can regulate the establishment, and that's what it's for. So the cost is going to be prohibitive, I think. I would hope we could maybe try to get the cost down for people, but I do think it will help us get rid of the bad actors. Thank you.
Anybody else like to speak on this? Anybody else? Not take a motion to close the floor.
Motion to close at the floor.
Do I have a second? Second. All in favor?
Aye.
Nays? Ayes have it.
Got a question for
Go for it.
So if I'm not mistaken, do we need to actually put in the ordinance that this doesn't, to exclude licensed therapists, since we do not have the authority to regulate licensed therapists? Isn't that already a given?
We are not this ordinance doesn't regulate massage therapists, it regulates the establishments.
Right.
So if you want to have an establishment of this kind, you need this license. It is possible that someone who is not a massage therapist could try to open up this type of establishment, but they would need to have a licensed massage therapist to actually operate. So there is that distinction there. As far as the intimate parts, it is for, that is part of the definition. We do call them out because in later parts of the ordinance, it is prohibited to expose the intimate parts. So that would be why we have a definition that is broad in that sense, for prohibiting exposure of it. So those are the, in addition to what you asked about, but kind of a clarification from the public as well.
And so as far as your research go, well, maybe we should open the floor again to see if, I mean, are these parts exposed when you do your therapy? But we'd have to open the floor. Hang on, let me, well, wait a minute. See if there's other things to get covered. We can do it all at once. So, this is for the business, not the therapist. And this would all be complaint driven, correct? I mean, inspections would be going in, but after that, it'd be complaint driven as for investigating if there's violations and if there's indeed inappropriate behavior going on.
I believe so. I believe that it would be partially complaint driven as well as just enforcement of our ordinances overall. I think the two would work in tandem.
I don't have anything else.
So talking about, it's just the establishment, if they have 3 massage therapists working there, you only have the one fee for the premise, right?
Could you say that? I'm sorry, could you
Say you have a massage business,
A spa.
a spa. There's only the one fee for the building or the establishment. It's not like if they have 3 massage therapists working, they don't have to pay $300, right? They just pay the one fee?
Correct, because this is an establishment. If they had multiple establishments, that would be a different question. The answer would be that you have to have separate massage license, massage establishment licenses for those 3 separate places. But in your scenario, where there's just one establishment, it's just one fee for that establishment. Does that answer your question?
Yes, sir.
Okay.
Thank you.
Yep.
Where did we come up with the $100? Did that, is that pretty standard, you know, for this type of?
Yeah, so that fee is something that we've seen across in different cities that have this type of ordinance. It is entirely in the discretion of council to determine what that fee should be. We would incorporate it in the fee schedule as well. So that is an amount that is up to discretion, but it is a number that we've seen pretty consistently throughout the state of Wisconsin.
Trying to remember what our fee is for alcohol.
That's a difficult question, because, so Class B beer is 100, Class
Right.
B liquor is 400.
400, right.
They can range anywhere from $100 to $400, and then combos, so up to 900.
But when we're talking about these fees, we want to make sure that they're reasonably related to the cost of what the services would be from the city's perspective as well. So I want to make sure that we're considering that factor as well.
And then one question for PD. Been involved with this for quite a while. Have you had any run-ins or any problems, or do you know of any legitimate establishment that we consider legitimate? Have they been on your radar? Have they been somebody you've investigated? Have they had anything to worry about from the police department?
In my 5+ years as a community police lieutenant, no. We haven't had any issues with, as the young lady said, if people are being compliant, doing the proper massages, we've never had complaints on that. And to answer your question, we are way too busy. It is complaint driven. We would only check up on a place if someone complained to us. We don't have the manpower time to go to each and every establishment all the time just to check to make sure they're compliant. So it would be complaint driven.
I can't think of anything else.
I just have a clarification. So if the massage therapist themselves is exempt from this because we're monitoring the establishment, if they're practicing out of their home, are they exempt because it's their house?
So to answer your second question, they can practice inside their own home, yes, but they would be included in this massage establishment license. They would still need to be included. They would still need to comply with the regulations. They wouldn't be, under the proposed ordinance, they would not be exempt.
So they would need to obtain a license?
For the establishment, yes.
Okay.
And you'd want that because otherwise, yeah, okay. Well, then I'd like to open the floor to get comment on, when you do work, do you need to expose these areas to do the work? And hearing that, this is complaint driven, that this is not something, we're not doing sting operations going around trying to do, your action to that, any comment to that.
Alder
So,
Scannell, once you've opened the floor, can you direct that question to a person who's already spoke, if that's possible? So you need to open
Sure.
the floor and then direct it to one of the individuals that spoke, provided testimony as a question in response to their testimony.
Make a motion to open the floor.
second,
All in favor?
Aye.
Nays? All right, ayes have it. 4, no.
well, first, Leah?
Yeah, I just need to clarify, it's the massage therapist that cannot expose those areas
Right.
on themselves. It has nothing to do with the person they're massaging. Is that the way I read it?
Well, there could be concerns with the other person exposing themselves as well, but we
But
wouldn't
I
have.
think in here, the way I read it, it appears that the person giving the massage should not be exposing those parts.
Well, it says of any other person, either.
Or of any other person.
Or of any other person, and, yeah, so it's.
Go ahead.
sounds over.
So when we work the glutes or the adductors, those parts are exposed. We drape them for their modesty. We drape them to make sure no exposed parts are out.
But then,
Right.
So, and with the, we drape, they're draped. They're completely, they have, what, 2-3 layers on? They have a sheet and they have a blanket on. And you move the blanket into the, I call it the forbidden region, pretty much. You put it over that forbidden region
The
and you
forbidden
use the
zone.
sheet to drape around the leg. That way you can work that glute or you can work those adductors. And then you, like, they're not doing a sting operation, so it's pretty much, we're gonna end up paying the same fee for the exact same result. It's not gonna change anything.
not for you, but we are going to be able to get at these establishments that are,
And I think they should make that just directly pointed to them, not the massage therapist who's having to travel and go here and go there and do massages here or anywhere like that. We always treat our customers with the utmost respect. We give them the most modesty. And I think this ordinance ruined it for a lot of massage therapists in the area. That's not.
What do you want to ask now?
So in regards to breast massage, which yes, absolutely we can do, it's in our scope of practice with obviously proper training, so it's not like we're just going around. But lymphatic massage, cancer, immune system issues, all of that, of course, we're gonna have to express that breast tissue so that we're able to work that. So yes, it is exposed.
okay.
And the state of Wisconsin says it's okay,
Right,
so.
okay, I think I'm good. Motion to close the floor?
Second?
Is there someone else?
I just have a clarifying question. Massage establishment is anybody who does massage in a place in the city limits. Is that correct? Is that a good description of what a massage establishment is? Because if I work individually, I'm one person. Do I count as an establishment? Or if I have employees, is that an establishment? Because what you're talking about is spa stuff, where you have a bunch of people that work for a company. If I'm working for myself, does that count as an establishment?
It still counts as an establishment.
Yeah,
It's a location.
right. And we'd have, yeah.
Go ahead. Oh, to clarify, I remember you speaking at our last meeting about going to people's houses with special needs. If they don't have an establishment, but they go to certain houses and stuff, that wouldn't affect them then?
We can't regulate what people do in their homes.
We can't regulate what people are doing in their homes in that regard.
Well, what about therapists that go to assisted living facilities or nursing homes?
Or Lambeau Field.
Or sports massage,
Sports
or
massage,
an event,
that's
No,
or...
This is, well, we'll address that when we close the floor.
I'm sorry, is there a question?
Saying he's
Yeah.
gonna close the floor, and then we'll
Yeah,
address these
yeah.
questions.
We have a second closing the floor?
Was there anything else?
Are their
That
questions
was just for
answered?
questions.
We'll close the floor.
I just want to make sure there's no other questions.
Okay.
You asked your question.
Motion.
Yep, second.
All in favor?
Aye.
Nay? Ayes have it.
Okay.
Additional comments?
Well, just, we're establishing ordinance for locations, spas, businesses, not someone going to other
Correct, yeah. I
Correct.
mean, we're dealing with private massages here. I think some of the things that we're describing here are more public-facing massages, like chair massages or massages in public. It's a bit what I'm hearing. So it would be a separate type of massage therapy.
Yeah, I think a lot of people are, I appreciate the concern, but I don't think this ordinance is going to be interfering with your business. We have to create an ordinance, and it's going to be some crossover. We're going to have to use some language that allows us to prosecute people who are doing inappropriate behavior. There's going to be some crossover there, but I don't see how a bona fide therapist that has got a state license and is following state procedure, rules, has anything to worry from this ordinance. It's not different from many ordinances around, and there hasn't been this issue. Staff has investigated this, so I can appreciate the concern how it sounds like we could be going after you. That's not the intent. That's not what's in practice. That's not what has happened, and I just don't see how we can create an ordinance that will allow us to effectively go after these inappropriate businesses that are not good for your business, unless we follow these procedures. And this is what has been done elsewhere. So we've held this up already to try and address some concerns, and I really feel that if this does become a problem for a legitimate business, I should hope you could step up, and we can always amend this to address issues. But going forward here, I think staff has done a really good job of investigating this, doing the research, and coming up with a product that will allow us to go after illegitimate businesses and should not affect legitimate businesses. I appreciate your concern, but I think we should wait and see how this plays out. I think you're going to be relieved. So I'm supporting getting this going and moving this forward with a recommendation to council. My 2 cents. I make a motion to approve. We can still talk about it.
Sorry. Do you want me to read?
No, you can, well,
You can do it now.
Just, I have a question about the fees. Can we separate a sole practitioner versus an establishment? Because you're looking at one person paying for the fee versus 3 or 4 people chipping in to an actual establishment to kind of help the independent people out, to make it more affordable. Are we allowed to have
I think
fees
you're
based on
certainly,
it?
council has the authority to change the fee amount.
Okay.
Breaking it down by person would be interesting. It's best to apply it across the board to all establishments, rather than treating them as massage therapists. We're focusing on an establishment. So if it's just one establishment, it has one fee, and it's not broken down by the
Number of
type
employees?
massage therapist and the amount of them.
Okay.
We could just reduce it.
Yeah.
Oh,
Just
you wanna-
I don't want to reduce it.
That case, something.
That's a lot. That's the fees for everybody.
But-
I don't know. Oh, do we have to say right now?
Well, if we're going to amend it.
Okay, no, that's a question.
Alder?
It's $100 for the whole year. I don't really think that, I think it's in line and comparable to other things. So I personally think that you want to have some skin in the game. I don't think it's.
Skin in the game.
Yeah, okay. I don't think it's out of line. But I do, I want to go back to my proposal for December 1st, and I figured out that it's going to full council on August 1st. To make it, I would say, more feasible, go 6 months out, so February 1st. From our full council meeting, so instead of December 1st.
So that would be the first, are we going to do this all in one reading? Or will it take 2 readings?
We can do it all in one reading. We can do a first and second reading.
And that's what
6
you prefer to
months out.
see happen?
That's what I'd like to see happen.
Okay.
Yeah, it's been delayed.
So 6 months out from there, so February So you want, what are you thinking of a different fee number?
I don't know, I just wanted to ask that question, if it was an option.
It's an option. Do you want to pursue it, or? Okay. Then how about we,
Would you like to amend your motion?
yeah, I would like to amend my motion, make two amendments perhaps, one for sure, one that we amend this to take effect February 1st. And a second amendment to,
I would like to see it down.
You can amend, you can have a whole list of items in one amendment.
oh, well then.
So if you have other changes, that would be a good time to.
Yep, the other change would be to reduce the, or to make the fee $75 instead of $100, $75.
What's your motion?
That is my motion.
Do you have a
The
second?
motion to rescind what you read out?
No, we do that.
Nope.
Oh,
Council,
okay.
yeah.
I'll take a second.
Second.
All in favor?
Aye.
Nays?
Opposed?
Ayes have.
Are you amending the draping exposed areas?
That's in, that would be covered. That would be, yeah,
So it's in the
Yep.
amendments?
should be. Yep.
No, it's not.
No, nothing, we're not changing anything.
Here, what did you?
If you read it, it really is about the therapist, not the client. Read
It
it.
says or others, so I don't,
It says exposing your privates to others.
or others.
It says to others. Letter I.
So is the,
It says or any other person.
is the intent of the ordinance concerning that language, that portion, the client or the therapist?
Well, I think a step back. The definition, again, is talking about the types of exposed, the types of areas. That's the other part, yeah,
I is the reference to the
there are,
definition.
here you go. Push it back. There are several sections that cover the exposure of intimate parts, and I think in the example that the gentleman gave, that if it's closed, it's not exposed. I understand the concern about the highlight about what the definition of intimate parts is, but the definition is used to clarify that the exposure can't happen. And so in this scenario, I don't believe that there would have been any exposure with it being closed. Break, thank you,
Even,
sorry.
like, when you go get a massage and you disrobe to your comfort level, that's what most licensed massage therapists
Right.
tell you to do.
Right.
If you disrobe to your comfort level, and then, let's just say you need the glute work, yeah, you expose that side of the glute you're working on, but you stop right there at the gluteal cleft, which you guys call a butt crack. You stop at the gluteal cleft, and then you drape them modestly, so nothing is exposed. You work those, either the deep sinks of those muscles, you work everything, and then you re-drape, you cover them back up, and then you continue on with the massage.
Yeah.
This would,
Again, I still don't think you have anything to be concerned about. I don't think any of your clients are going to be filing complaints that the police are going to be investigating. I don't think,
But if it's in the ordinance, then that's what the ordinance states. That
the
means that-
ordinance is enforced by the police department.
No, inspections.
Well, in the beginning.
No.
For-
Inspections is, that's what the whole.
Right, but the inspections is not going to be able, inspections is not going to go in and watch a massage. The inspections is going to cover other parts of the
by law,
ordinance.
we can't.
Yeah, they're not going to be, so that's police enforcement. And again, I just, we need to create an ordinance that will allow us to get after these illegitimate businesses. There's going to be some crossover with language and practices, but there's a difference between a legitimate therapist and an illegitimate
That's
therapist.
why we're
I
asking
think,
for an exemption on the wording,
Yeah, I feel
because
like-
we have to follow the law.
Yeah.
well,
I
but
know.
that's a given. State law already tells us we cannot.
Alder Scannell, can I suggest an amendment?
Yeah, I'm sorry,
Very
I'm
fine.
arguing,
I
yeah.
think to clarify your purposes, we could create an exception in that area that says unless acceptable under state law for a massage therapist. So the practice of the massage for the person's breast cancer, whatever it might be, so as long as it's acceptable under state law, I think we could carve that out.
Do we need to amend?
Could add it to your amendment list.
Well, we
I
already
need
voted.
another, I need another motion to amend that to include an exception.
Yep, I make a motion to amend the ordinance once again to include the language
The exception for
An exception for-
practice that's acceptable under state law.
Practice that's under.
For a massage therapist, the practice of a massage therapist under state law.
Second?
Okay, all in favor?
Aye.
Ayes have it.
Okay. Appreciate everyone's concern on this. You know, we really want to come up with the best law we can. But we,
We want the same as you.
right,
We do.
we do. Yeah,
We
I know we're on the
just want it to
same.
be fair for us,
Yep.
too.
Yep.
All right, thank you. Ready?
Motion to approve as amended.
All right, second?
Second.
All in favor?
Aye.
Nays? Ayes have it. All right, on to number 7, consideration of possible action on appeal by Jennifer Larson regarding denial of her operator's license.
Yes, thank you very much, I appreciate it. Thank you. These are the planning commission, so just take a second here to switch.
Thanks.
Yes, thank you.
We read it.
Yes, referring to the police department for their reason for the denial. Yes, we're on number 7.
Reason for denial looks like a recent operating while intoxicated charge in 2022 with a PAC enhancer. That's it.
So not a felony conviction that's mandatory, but based on,
The other part of the language that says, yes.
that allows you to consider recent convictions. It's a conviction.
Motion to open the floor.
Second.
All in favor?
Aye.
Okay. Hi, I'm Jennifer Larson,
May you
and
state your address, please?
my,
Address.
oh, 5053 Blonick Road, Denmark, Wisconsin.
Right there.
I'm here to appeal my denial for my application of my beverage operator license. I've been bartending at this business for over 19 years, and it is my full-time job. It is my livelihood. The shifts that I work, I am by myself, and I've never had any problems or issues with the city or the Green Bay Police Department at the establishment that I work at while I'm working. And I understand in order for me to work, I have to have the license. I mean, there are cases, as long as somebody's there, it's okay, but like I said, I am by myself on my shifts. And I, also with my misdemeanor conviction that happened on my own personal time, I don't think it should be fair to have it affect my job. I was taken by surprise when I was noted as having a repeat criminal behavior and being a habitual law offender. I mean, yes, it wasn't my first offense, but it has been 22 years since my last one. And ever since this one that happened last year in January, I completed all the necessary requirements that were given to me at my sentencing. I did email some copies, I wasn't sure if they were received, about the counseling, having the interlock put in my vehicle, which requires me, I can't drink. And also there was a thing noted on it that there was an exception for me working at my establishment. So that's really all I had to say, but I just hope that this will help in your decision in a positive way for me. And thank you.
Any questions for her?
Thank you.
Thanks.
Motion to close the floor.
All in favor? Or do I have a second?
Second.
All in favor?
Aye.
Nays? Ayes have it. Any comments, questions?
Yeah, I think, you know, it's not a felony, and certainly she has proven that this isn't going to be an issue going forward. This is her livelihood. Been 22 years since the last one, and she has interlock now in place and gone through the counseling and everything, so I don't see her as a risk to the public. So I make a motion that we
Grant the appeal? Is that what you're asking?
grant the appeal.
Second.
All right, I'm gonna grant that question. Go ahead.
Does police have anything to say about this
It's not
establishment?
final until Tuesday.
I didn't hear what establishment she's working at.
I didn't
Oh,
either.
BB's on Main.
No, we've never had issues there. They've been very helpful and compliant whenever we have any, we need video or whatever, so never any issue there.
Thank you.
Okay, is that all in favor?
Aye.
Nay? Ayes have it.
And then this is,
Yeah, so everything that's discussed tonight is a recommendation to the next common council meeting, which is scheduled for August 1st. At 6 p.m. Okay?
All right, thank you.
Very welcome.
For your time.
Thank you.
All right, next, consideration possible action on appeal by Gregory Dyring regarding denial of his operator's license. Please.
Denial due to being a convicted felon and registered sex offender. So,
Motion.
sorry, felony, looks like it was from, we've got 2019.
yeah. Motion to open the floor.
Do I have a second?
Second.
All in favor?
Aye.
Nay? Ayes have it.
Thank you for this opportunity to speak with you tonight.
Mr. Gregory, if you give your address as well.
I live at 149 Burger Street, Green Bay, Wisconsin, here in town. I'm just here appealing my liquor license, my service permit. As the police officer stated, my crime happened back in July of 2019. What I did was a huge mistake on my part, and every day I think of that, what I did. But I was convicted. I actually pled no contest to the charge and was convicted to 1 year in jail, which I was allowed to serve on EMP, electronic monitoring program. And the judge on my case, I know I gave a bunch of a packet, you guys saw it or not, Judge Hawk, on my case allowed me to keep working at the establishment I work at while I was on EMP. She said I could keep working there in Schumer. So the whole year that I was there, I actually had to do breathalyzer tests every 3 hours at a portable breathalyzer. And kept working. I had 2 places, home and work, and that was it that I could go to. I've been since released off of that. I'm still working at the establishment. I've been there for about 11 years. I've been bartending in the bars here in Green Bay for over 30. Like the lady said earlier, I got the letter in the mail saying I'm a habitual offender. This is my first offense ever, so I was kind of, like she said, taken aback from that. Because I didn't understand what that meant. My crime had nothing to do with alcohol, illegal substances, or anything like that at all. It had nothing to do with me at work. I wasn't pulled over after drinking all day and committed my crime. None of that ever happened. It has nothing to do with my livelihood and me working in the establishment. The bar I'm working at now, we have never had a complaint from the police department as far as having to call the police for any fights or anything. We're a small town tavern. We don't have a huge crowd come in. That's it. Please, it's my livelihood. This is all I do. It's a full-time job.
Any questions?
Are you by yourself at times at this establishment?
I have 2 different shifts. I'll either work from 1 to 8 or 8 to close, and it's almost always one bartender on. There's no second bartender.
What's the establishment?
The roundabout on Main Street, right across from last night's accident.
Please, any concerns about the roundabout?
None at all.
Okay, perfect.
You don't go roundabout?
We have enough roundabouts in this city.
Motion to close the floor.
Second, all
One
in favor?
clarification for him also, we were, the habitual, that's the habitual law offender or a felon, that's the way the state law reads, so that's in the template. But in this case, the state law requires us to deny a felon regardless of circumstances, so this is the process we have
I
followed.
understood that, that's fine.
I just wanted to make sure you didn't think we identified you as a habitual law offender.
It's just the way it reads, it's like, what?
I'm seeing other people that have sent letters of,
Actually, 2 of them are here tonight that
yeah,
sent the
that's what I was
letters.
just gonna ask, do any of them wish to speak?
Oh, well then
I will, I didn't write the.
That's my boss.
Okay.
Hi, do you want me to come to you?
Sure, yes, please, state your name and address.
Amy Gustafson, 1625 St. Agnes Drive. Greg, my employee, friend, he's been my employee for 11 years. I understand, I've been with him through this whole process that he went through. He did serve his time. He did everything that's been asked. There's no incidents. He's in a place that you have to be 21. Alcohol, that was never a factor. And as far as I'm concerned, he's proven that he's a quality person for this community. And I absolutely keep him employed. And I love him. If you could take that into consideration, the judge ruled it as such from his case, and I feel that that should be good enough to go forward. That's all I have to say. Thank you.
No question.
I have no questions. Thank you for your time. So we have a motion to close the floor.
Motion to close the floor.
Second.
All in favor?
Aye.
Nays? All right, ayes have it. I will take a motion to approve.
I make a motion to approve the appeal.
All right, do I have a second?
Second.
All in favor?
Aye.
Nays? Ayes have it. All right, goes to common council on the 1st of August.
Next week, thank you.
You're welcome. Ready?
Yeah.
Consideration of possible action on the appeal by Jesse Robinhurst at 1905 Decker Avenue regarding reinspection fees. Dan?
Sure, I'll start. So on a procedural matter, I would recommend denying the appeal because to my knowledge, all of the invoice dates are past the 30-day window. The most recent one, I believe, is January 25th, dating back to 2022. Each invoice says that appeal is required within 30 days. That time has passed for all.
Well, I'd like to hear from the complainant as to.
Is that you? Are you here for that?
Yes.
Motion to open the floor.
Second.
All in favor?
Aye.
Nays? Ayes have it. The floor is now open.
Staff is here as well to speak. Again, if you want to hear, that's fine, but I will strongly recommend denying on the timeliness, so we will have to hear them all in the future, regardless of timeliness, so.
Yeah.
Come up if you'd like to speak.
Hi, I'm Jesse Robinhurst, 1905 Decker. I started, may I sit there?
Sure.
Okay. I started siding my house 2020, July 4th weekend. Since then, I've had health issues and couldn't pay my contract. So in May of last year, or April, I got a letter from the city to get something done about it. I've been off work almost 2 years now because my job can't take my restrictions for my back issue. I also had a knee surgery in between there. I feel it's, I kept in touch with Mr. Meaves, and he kept telling me that his boss wants a timeline, and I said, I don't have a timeline. I'm trying to live on disability. I can't afford to side my house right now. So he started finding me, and I believe up to 20 times in 8 months I've gotten fined. And I kept in contact with him. He kept telling me, give me a timeline, give me a timeline. I said, I don't have one. I'm off of work. So anyways, finally in January, he called me and told me about this NeighborWorks thing. And I went down there immediately the next day and got the papers, what they needed, whatever. So that's been, what now, 6 or 7 months that they've been going through the city and getting their paperwork done and stuff. Everything's signed, everything's ready to go. I am just waiting on the contractor, and I just spoke with him last week again, and he has me scheduled to get this work done, started the week after Labor Day. Now, I have, what is it, I don't know if you have my paperwork up there at all.
Some of it.
$950 in fines right now due, plus the $350 they took out of my escrow last year. Also, I got a $740 ticket from the courts that I had to pay last month so that I didn't lose my license or have a warrant out for my arrest or whatever. You know, I didn't ask for this trouble. I mean, I don't, it's kind of like taking candy from a baby. I mean, geez, I don't have the money, so you're just gonna keep nailing me with fines that I can't afford to pay? I would like to see them reversed. I don't know that we can do anything about the court one, but, I mean, that's $800 that I gotta pay my uncle back for that, $740 or whatever it is, which I don't have either. I am right now in line for my next surgery, just waiting for it to get scheduled. Hopefully this one will work and I can get back to work, but as of right now, again, just trying to live on disability payments.
Okay, then, but it's been over 30 days since the last invoice, is that correct? And so that is beyond the time for the appeal? Is
I'm
that-
looking at the list that dates from October 6, 2022 to January 25th, 2023. Are there others? No, that's the list. So a fine
But there was 350 that went on to the taxes, which back then it would have been previously.
So that would have been even earlier. And I was just going to look up, I'm not sure what the the fine is. I don't think that's from the city. The other action he's speaking of, I don't think that's a city fine.
Okay.
Well, where did it come from then?
I'm not sure what it is. I'm looking for it right now.
It was a citation.
Okay, but we stopped, reinspection fees at what date?
The last one was January.
Last one was January, okay, so, okay. So unfortunately, by statute, I'm assuming, correct, that there's a 30-day period given to appeal city action, and that 30 days has lapsed. So by ordinance, we really can't take this up. Is that?
I mean, you could suspend, if he was being assessed weekly, you could suspend those and give him more time to comply with the order, but in terms of the fees that have passed, I mean, there's still an outstanding order that hasn't been complied with, but it doesn't appear that we're fining him weekly because, or assessing
Right, they
reinspection
stopped.
fees because we understand that he's working with NeighborWorks.
Right.
Correct? And there's a timeline to get that finished. Maybe you'd like to hear from staff on that?
Well, I would just like to hear, how did you come about to bringing this appeal now? Why not sooner? Do you know, what was your thinking, what was your timeline?
I didn't know where to turn or what to do. I couldn't get him to stop fighting me. Again, like Cody told me about NeighborWorks before he started fighting me. I had no idea about this place. Like I said, as soon as he got a hold of me and told me about it, I was right there at their door, get whatever they needed from me.
Okay, what was it that spurred you to file the appeal now?
Because I can't afford to pay these fines.
Okay.
I mean, they're just taking out my escrow and my property taxes won't get paid.
Right. But they stopped finding you in January.
They stopped finding me in January as soon as he told me about NeighborWorks.
Right. So why wait till now to appeal it? Why not?
I guess I didn't realize that I could appeal. I didn't know what to do.
Okay. All right, thank you. I got no other questions.
Any other questions?
I'd like to know if staff has anything they want to tell us.
Well, we should close the floor. Motion to close the floor.
Second?
Second.
All in favor?
Aye.
Staff, do you have any input for us that you'd like to express?
Sure, I brought the inspector that was assigned to the case, Inspector Tim Means is here. If you have any specific questions for me, I'm more than happy to answer your questions or concerns as far as how we receive the complaint and our process.
Like I said, I have a question for you. So you guys are he's now working with NeighborWorks. What's the timeline, do you know?
Mr. Robin Horst was, his application was approved to receive federal grant monies for energy-related projects, of which this would be because it involves siding of his home. So that project was approved, it's going forward, and as he said, the contractor is set to start work September 6th, or that week right after Labor Day. So.
And I want to thank staff for bringing NeighborWorks in. I think that's a good process. The more we can start letting people know about resources available to help them out, I think that's a really good thing to do.
Yes, because literally just a few days before that, Mr. Robin Horst had indicated to me that he was going to seek assistance from friends and family to start this project, acquire the materials needed, provide labor to install the siding. But it was the very next day, January 27th, where he backed out of that and said, no, they've got full-time jobs and other commitments, and they can't help me. And it was literally, I think, 3 days later, January 30th, I caught wind of these monies that were available, not knowing if he would qualify for the program or not. But I put him in touch with NeighborWorks to begin that process. And it took a period of months for review and things like that, and the application review. So he was found to be qualified for it, and now it's moving forward. Originally, this complaint was received back in March of '22. After sending a 30-day notice to fix this violation, I heard from Mr. Robin Horst a few weeks after sending the notice to him, and he indicated some hardships that dated back to August of 2021 that prevented him from getting the home resided. But a neighbor is telling me, since they moved into the neighborhood, this went back to 2019. And so I questioned him as to what happened in that 2-year period. I didn't really get a response for that, but so.
Were these grant funds newly available in 2023? Is that why we didn't give the idea in 2022?
Oh, I'm sorry.
The grant funds through NeighborWorks, was it a 2023 funding, or were these available in 2022?
They were, according to the contact I have at NeighborWorks, they just became available at the beginning of '23.
Okay.
I have a question. So what's the grand total?
$950, I believe.
So there's $950 in reinspection fees and then a reimbursement of $350. That's because that went on to the taxes. It's two separate matters. So one would be waiving fees that haven't been collected. The other part would be actually paying back. They've been collected as part of property tax.
Okay.
So the $350 went on the property tax.
Bill, yes.
So can we waive any of these at this point in time?
I mean, this did come before us, but it sounds like by ordinance, we are kind of tied.
Yes. It's in your purview to do so, but as I said, I would strongly suggest not because of the timeliness. Every inspection, every invoice says specifically on the bottom, it's due within 30 days unless an appeal is filed. You can see that in your packet. Each document has that notice, and the information is on the back of that sheet as to where to appeal.
In addition to the reinspection fees, I did cite Mr. Robin Horst into municipal court. He missed his appearance date, his initial appearance date, so he was found guilty by default. It's at that appearance date, where you enter your plea, and a pretrial can be scheduled with one of the assistant city attorneys. And at that point, there can be some negotiation as to what can you do and when, perhaps. And so that meeting never took place, unfortunately.
Would it also be inadvisable to take any action, say to cut it in half, the reinspection?
Half of the 950?
Yeah. Would that also be opening up a can of worms with our timeline?
I don't know. I guess it's your choice. It's the same point.
Same point.
Same point about the timeliness. And again, we haven't assessed a fine since January because we assume we're on a timeline for compliance.
Right.
So it's about 8 months has passed, or will pass before the project starts. You can, certainly, it's not prohibited.
Right.
I just advised against it, but obviously it's your choice. And if you did, I would just say you should state a compelling reason why you're doing so. So we don't create a precedent of just doing it.
Well, maybe I can give a compelling reason. I think, okay, thanks, go ahead.
Yeah, if I might add one more thing. I don't have my notes right here right now, I have them over there, but
Go ahead.
all right, thank you. It was July 20th, 2022. I paid a visit to the property. Mr. Robin Horst wasn't home. I called his phone, there was no answer. So I left my business card attached to his residence with a note asking him to please provide me with a letter detailing the circumstances that he was experiencing or going through, and why hasn't the home been recited. I never did hear from him with a letter or otherwise.
I did call.
Just basically the hardship issues, financial and or medical related.
Yeah.
Thank you.
Thank you.
I'd just like to note our procedure, how we do the reinspection fees.
Yep.
They're staggered with an intention of generating communication.
Yep.
We are more than happy to communicate. That's the whole intent and purpose of it,
Yep.
is to establish communication so we can get to compliance. It's a two-way street, but we're opening that means that we need to hear something back. If we don't hear something, we have no other means of proceeding forward with correcting an issue.
Yep.
And we're willing to work with anybody. And when we see progress, all the better. At the end of the day, it's Mr. Robin Horst, it's his responsibility. And I have, whether it's elders or whether it's neighbors, calling me constantly. Tim, Inspector Tim, you're not doing anything. I've been looking at this for X amount of months or years. You're not doing anything, you're not doing your job, the city doesn't care. That is some of what I have to listen to, and I understand that goes with the job. So, am I out to penalize people and put them in a bigger financial hole by design or on purpose? No. Just simply doing my job to the best of my ability. That $950 easily could have been 2 or 3 times that amount if I would have made more visits.
I really appreciate you bringing up the NeighborWorks application. I think that's very helpful. I think it's very important that we try to help our residents the best way possible. And I'm very relieved that you got approved and it's moving forward and that'll be completed for you too. I think that's a big win and I really do. So thank you very much for doing that. Because that's a big complaint I hear is that we don't work with our residents. So I appreciate that.
And I think staff has done everything appropriately, and I have no complaint with staff at all. I think you've done a great job here. I'm just thinking that if he had, within that 30 days, come forward and explain things as he has now, we might accept his hardship plea and have worked out something with him. And that he didn't do it within 30 days to expect, I mean, yes, it's on the form, but I mean, I've had people who, you know, they get a form from they get something, they get a bill from the city and it's all panic button, they can't think straight. And that's regrettable that he didn't contact at least his alder or something, or, you know, to get more help sooner, so we can address this sooner and deal with it sooner. It does make it more complicated now that by statute we've gone over your date for an appeal. Technically, we shouldn't. That's what confuses me. If it's gone beyond the date to file an appeal, how can he file an appeal?
So appeals of this have to come directly to you. So this is your opportunity to either accept it, grant it, deny it. The clerk's office doesn't have that authority because an appeal has to be made to the Protection Policy Committee.
So the 30
staff cannot reject it.
Staff can't reject it. So what's the purpose of the 30-day limitation? What is that? How does that do? What is that
So
supposed to?
All of our appeals have a process because otherwise we would have an indefinite period of time. So we've created a statute, basically what you would consider a statute of limitations for appeals, for administrative process. All administrative functions as well as criminal penalties, tort actions you can bring, all have a limit. Just like when you deny an operator license, when you deny a liquor license, we have a time frame for that.
But it seems like that time frame can be excused or ignored, or that's what's confusing.
We haven't in my experience. We've granted some, I've not seen one granted that was late. I would also say sometimes when you decide to waive the fees, it's because the order has been complied with and the work has been done.
Or about to be done. I've done it where it's, you know, everything's in order.
But usually
and
it is
it's
a timely
yeah.
file.
Yeah. I see this as a hardship case, and I just hate to be making it more harder. I think staff did the right thing with, I mean, the reinspection fees are supposed to get compliance, supposed to get contact, supposed to get things moving, and that didn't happen right away. So I think, but when it does happen in the past, staff has been pretty good about either waiving those or cutting them in half, or sometimes, depending upon the circumstances, saying, you know, we should stick with them. And it just seems, you know, someone who's been out of work, someone who's got a medical condition, it just feels a little bit, if you had followed the 30-day limitation, filed within that 30 days, I would have been inclined to work with them on at least reducing the fees, if not rescinding them or something, because we do have what we want. And thanks for staff for, again, bringing NeighborWorks into it, otherwise we probably wouldn't, you know?
In response to your point, Alder Scandal, I would say under past circumstances, we would, once we obtain compliance, absolutely waive. So in a situation where we would have been citing him since January 25th, you all probably would have decided to waive these, but these are all for a point before we had any assurance of compliance.
Right.
So.
I'll make a motion, open the floor again.
Second.
All in favor?
Aye.
Ayes have it.
I'm dealing with Jeff from NeighborWorks, and he speaks to Mr. Meaves. He's kind of like my middleman. And he had said that Mr. Meaves had said it would be better to have a plan that you know that it's going to get done before you even come and do this. So I don't know.
When was that? When did you get that in?
I've been working with him since February 1st or whatever, whenever he got hold of me. So that was, I couldn't tell you exactly when it was.
That's still past the 30-day notice, the last one from January. Okay. Anything else?
And he mentioned 2019, and I know for a fact it was July 4th, 2020, COVID, that we started. So I don't know who complained and said it was 2019, or that wasn't the issue.
Plain, whatever, that's neither here nor there. Okay. Anything else?
So you were accepted in February by neighbor, that's when you found out that the project was accepted?
I wasn't accepted right away.
Okay.
It took paperwork and time and whatever.
Do you know when you were notified that you were gonna be good to go and Labor Day and?
I'm sorry, I didn't write that down. I'm
Okay.
sure Jeff would know, but I didn't.
Okay.
I didn't
Roughly?
have that. I'm sorry?
Roughly the month or?
That I wasn't gonna be okayed? I think it took like 2 months before they got back to me to say that was.
Okay,
And I believe he's newer at the job and there's newer people there, so with the paperwork and having to go back and forth with the city and stuff caused the delays, as he had said.
Question?
No, I'm good.
Motion to close the floor.
Motion to close the floor?
All in favor?
Aye.
Ayes have it. Comments, questions?
Well, I,
I appreciate that he applied as soon as he found out.
Right.
He took action as soon as he found out there was a avenue to go down. So that I can appreciate. It's not like he dragged it out halfway
Right.
through the year and then did apply. He did qualify and the project's moving forward.
Right.
So I think that's worth something to consider. And I get it, what are you to do if you don't have the?
right. And I don't feel that he was purposely jerking staff around. I don't feel he was purposely trying to scam the city. And it is he was unemployed because of a medical condition. So I really hate to make further burden on him. I think staff was right in their responses, but now that we've got what we want, which is compliance, and we're fully aware of all the details that he wasn't, taking a vacation, saving money to take a vacation instead of doing his work or something. There's a real hardship case here. I would like to at least cut him in half. I mean, I think if he had done it within 30 days, he might have been able to rescind them. I don't know. I really feel the less burden we can put on him, the better, in my opinion.
Half of the 900 or
Wait,
half
no, I
of
have a
the-
question for the attorney. So the 950, does that include that 350 that's already in the
No,
tax bill?
no, no.
Separate, it hasn't been collected. I would suggest if you're gonna reduce, I would do it from the 950,
Yeah,
because
that was
the
my
350 is a separate issue that
Right.
requires reimbursement.
Right,
I would not touch the 350.
right. I wasn't gonna go there.
Okay.
Yeah, I mean,
So 950.
yeah, so.
Thank you. Clarify.
So two things, if you're going to make this motion, I'll just I would say, state the dollar amount if you could.
Yep.
And like I said, the compelling reason why.
Yep.
And then also contingent upon completion of the project.
Project, oh, yep, yep.
Order closure.
Yep. I was just doing the math in my head. 375?
Is that it?
No, it's more than that.
It's 475?
Yeah, 475. I will make the motion that we reduce the fees to 475. And the compelling reason is that this is a hardship case. Mr. Robin Hurst has been unemployed. He does have a medical condition. Knowing all the facts, I believe he never intended to scam the city. It's unfortunate that we don't have the communication, the connections that we like to see happen, and it's on him, it's on his shoulders that didn't happen. Staff did what staff needs to do, but given the hardship and given that a lot of people, even though it's on the forms, they don't know how to work with the city. And it's unfortunate he didn't call us all to get some more help on that, or call the city to get some more help. Staff would, I'm sure, would have helped work you through. But I can just see how many people not used to how the city works, don't know how the city works, just getting lost and swamped, no matter our best efforts to try and guide them. And considering the hardship of the case, and of course, it needs to be dependent upon the work actually being done, which with NeighborWorks involved, and it's been approved. I feel confident that's going to happen, but it still needs to be contingent upon the project being completed. So that's my motion. Reduce it to $475, and for that compelling reason, and with that stipulation.
Second.
I don't know if I'm okay with that.
You want more or less?
I'd probably motion to amend to, I'm only thinking a third because I wish we would have had contact sooner. I know neighbors, it's hard on neighbors too. So I see both sides. So I would amend to reduce, well, yeah. Reduce it by I'm sorry, no, not by 300, I'm sorry. That we would take off 300. So
Whatever.
reduce it to 650.
Reduce it to $650.
Mhm.
So would we first vote on mine and then on her amendment, or should I amend my amendment? She wants to,
She's trying to amend your amendment.
Amendment,
So you
yeah.
can vote on that first, probably.
yeah, so let's vote on mine and then,
All against it.
or,
No, we vote on the amendment.
On the amended.
I'm on the amendment,
All
okay, and then,
against
okay, all right. So we'll vote on your amendment first.
Second.
Second to reduce it by, so what the,
Reduce it by 300, you would charge 650 instead of 950.
so to reduce it to 650.
A third of the cost.
Reduce it to 650. Well, if that's,
I'll second.
okay.
All in favor?
Aye.
Nays?
That's what it takes. No. Do you want it reduced more, or you want to keep it at,
No, I vote to deny that appeal.
oh, you voted, okay. All right, well then there's my motion. That's been amended.
Who we just approved my amendment?
Yes.
3-1,
Yeah, so
yeah.
now you have to
Okay.
vote that, which is to,
Approve the amendment.
Oh, okay.
to approve the appeal, which is basically to grant the appeal on the $300 of the inspection fees.
Motion?
The motion to, well, my original motion, but that's amended.
Correct.
Yes.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Nays?
Nay.
3-1. Let me know when you're ready. All right, thank you. So it goes to common council next week for final approval.
Same building?
Yep, right next door.
I think she got that written down here for me. Okay. Thank you.
You're welcome. Consideration of possible action on the appeal by John Rome, 1315 South Oakland Avenue regarding reinspection fees filed with the law department on 1/11/2023 and previously discussed at the January 23rd Protection and Policy Committee meeting. Staff?
Yeah, just a reminder, Mr. Rome was here earlier this year, as it says, you all gave him a time period to come back by. I think that was a date in May to complete this work. And then staff from inspections provided additional information that I think the last month they've been there to follow up inspection and documented progress and reminded us of the need to return to committee because the order has not been completed. And as I said, staff from inspections will provide more detail on that.
Staff? Inspections?
You can stand here if you'd like, or if you, wherever you want to. It's fine.
And I'm sorry, was there a question right away?
Oh, just what the current status of the property
Oh,
is.
okay.
Thank you.
Yeah, so right now the current status is, I visited the property today, met Mr. Rome on site, and regarding the shed in question, he has siding on the rear to complete installation of, and the back side of both sides has to be completed for re-siding. The roof, there's new sheathing installed and tar paper, shingles next. So that's the major work that has to be done yet. He informed me that work would be done this week yet, and that they have all materials on hand, on site to finish the job. So, as of today, this is where we are.
Motion to open the floor.
Second.
Well, contractors,
All in favor?
Aye.
thank you, board.
State your name and
Must have-
address for the record, please.
John Rome, 1315 South Oakland Avenue, Green Bay, Wisconsin, 54304. I've just had contractors from Hill. When I initially called them, they had already taken on summer work. You know, people pay up in advance, and then so the summer is quickly taken away. And so, in doing so, I've got a guy now that I'm working with that promised that it could be done, completed this week.
What's the total reinspection fees?
725, but, you know, I guess all of them are in play, so.
It's fine. We held off on 7, you said 7.25 is what's left then?
That's the figure.
Yes, yep, I can find out what the exact dollar amount is. We're going back to the minutes from the January meeting. He had some inspection fees that were beyond 30 days.
Yeah.
Anyway, we can get that as you're talking about compliance here.
Questions?
Yeah, well,
You can have.
now would be the time to.
Is it okay to ask questions, staff? Okay. How has communication been since January
I'm sorry.
with Mr. Romes? How has communication been with Mr. Romes since January?
Yeah, he has communicated, he's requested, I mean, I think you set a deadline of first week in May. And since that time, there's been 4 to 5 requests for additional time. A fallen tree in the front yard, weather, unreliability, I think, of a contractor or workers. So, I mean, he has been communicating, it's just has moved along at a snail's pace, if you will.
But considerable work has been done.
I'm sorry?
Considerable work has been done. It's just the back half.
At this, right, now at this point, as of today, it's certainly beyond the halfway mark.
And all materials are there, right? You said.
Yeah, just gotta get the contractor.
So you were there today and you saw the materials?
Yes, this morning.
I believe, if I remember right, part of it, the complaints too were like debris alongside the building, lumber and stuff laying there. Has that been cleaned up?
Yes, that original debris has been removed. There is a considerable amount there today that's in a work trailer.
Okay.
So related to the
But it has
repair.
nothing to do with the initial complaints.
Correct. So those are items that, will have to be disposed of properly.
Yes.
Any other questions?
I got no questions for Mr. Hall. I'm good.
I have questions.
Motion to close the floor?
Motion to close the floor.
Second. All in favor?
Aye.
Ayes, ayes have it.
Okay.
Comments? Concerns?
Seems like things are going compliance is in the works. I'm just trying to remember, as far as, I don't remember what we said about the fees when we last met. Were we talking about rescinding those if he finished the work, or?
You held them until
We just held them.
decided in May.
We just held them.
If it was going to be completed in May, Mr. Rome indicated that if you gave them until May, that it would be completed.
Okay. Well, I think,
I guess my question for the committee is, deadlines in our line of work are very important.
Yeah.
They spur action. We have to have a point that says it needs to be completed by this point, or enforcement action has to be completed. So I guess that my question for the committee is, what type of timeline would you feel it is important that you give us direction so we know how to operate, to be able to
right. For me, I think you're doing.
To resolve complaints.
Right, I think you're doing your job perfectly. I think you're doing the right steps. I think that when something comes up beyond the property owner's control, as long as he's in communication with you, as long as he's trying to be compliant, then we're getting what we want. You've set a date, you've given reinspection fees to get that communication, to get that compliance rolling. It's just a matter of, has something come up that has prevented him? Is it a bona fide excuse? And is the intent of the property owner sincere in being compliant, or are they just trying to jerk us around? And that's what I look for as a committee. If I feel we're being jerked around, if I feel staff is being jerked around, that is not acceptable, you know?
Alder Scanlon, I would suggest we have to have hard and fast. Has he hired a contractor? Do we have a contract? Do we have a quote? Do we have an estimate? Do we have payment? It's not enough about how we feel that their communication has been, how their treatment has been, in order to reach some finality on some of these things. We need evidence that's obvious in terms of whether it be written documentation, receipts, things of those nature.
Well, he has all the supplies, so that's evidence. I mean, I do understand contractors book up quickly, especially in the summer months. That's their busiest time of the year. And maybe May wasn't reasonable on our end. But I am happy that everything is confirmed, that materials are there, the other issues were taken care of. So I do see what you're saying. And I see hard evidence of him trying.
Alder Stevens, was your question to me, did I see the remaining?
Yes. Did you see?
I did not. I'm
Oh.
sorry.
Oh, because you said you were there today.
I was there, yep, I did not see them, I just posed the question. When, after he indicated that the project would be finished this week, I said, okay, and you have all the materials to complete the project? He said, yes, I did not see them.
Well, I
I'm
thought you stated
Yeah.
you were there today.
Yeah, I was there today, but I didn't see them outside on the property, so I don't know if they were inside.
Yeah, that was my question.
When were you gonna reinspect?
Well, I mean, originally it was early October.
Right.
That became April 27th or 28th per his promise.
Right.
And that, well, then, at the prior PNP meeting, it was May. So, and since that time, there's been 4 or 5 requests for extensions.
Extensions.
Because it just wasn't getting done for different reasons.
Right.
So, at this point, after discussing it with my supervisor, we thought it was important to bring it back before the committee. And, you know, here we are, we're gonna be until August.
Well, if I recall correctly, everybody that's involved here, us and John, like, we all agreed on May. To have it finished.
Right.
How many inspection fees were issued since May till now?
Have any been issued since, from?
None.
No, they've
None, yeah.
been
None.
on hold pending.
Oh,
Yeah,
they've been on
they've
hold.
been
Yes,
hold,
they've been on
yeah.
hold.
This is all inspection fees from,
When we grant an extension,
Yep.
or they're working with us, no fees aren't issued. Fees are a cost for service of us sending staff time out there to follow up and push compliance on the project. If we grant an extension, or the committee grants an extension, we're gonna give you the state to get stuff done. we don't take any enforcement action until that deadline hits. That's why when I'm at, my previous question, that's why deadlines are important to us, is we need to know how we need to operate after we hit that deadline. Because we need to take some action in order to push compliance. Otherwise, some of these may take a lot longer to be resolved.
Well, we're still in the middle of this. I would recommend we hold this until completion to discuss the fees. To reduce our complaints.
Well, I was gonna make a motion
Can we do it?
upon completion.
Yeah.
But we could hold this until, he said it's gonna be done this week, so hold it till our next meeting. And inspection can check between now and our next meeting to see if it's done. And then we can hash out what would be appropriate for reinspection fees or.
So to remind the committee about reinspection fees, I'm sorry, it took me a minute to pull back to our minutes. So we were looking at just the fees from 12/14 through January 9th because his appeal was filed January 11th, and that's $400 worth of reinspection fees. That's what we held, pending completion of the work, and you gave them until March. I'm sorry, May. Apologies.
So the direction my response to your question, did that make sense? Is that helpful, or does that help staff, or am I not being helpful here?
Based on the last decision, I'm confused based on how those timelines are going to be.
Okay.
The previous case that we opened up that creates more questions. As far as how we're going to operate, meet deadlines, how enforcement, how we're going to utilize that as a tool for enforcement, for compliance.
I mean, certainly,
I'm not in agreement.
I've been visiting the property since May.
Right.
I was there May 5th. Nothing had been done to the shed.
But the
At
front
that
porch
point,
had been...
You know, and so I held back from May 5th until I have issued no additional penalties.
Right.
And I think I probably had every right to. And maybe my supervisor is going to remind me of that, you know.
So that.
I mean, yes, we were communicating, but.
So theoretically, if we were to issue those fees, and let's say it takes 2 years to comply, we've now established a new deadline and a new precedent that 30 days for reinspection fees can be
We haven't
looked at.
created any precedent, Bill. We're not going to talk about the last case in terms of precedent because it hasn't been decided. And also, it was just a $300 discount of the totals due to a hardship, not a waiver of the fees, is how it was approved. So, not to interrupt, but I'm just saying that hasn't been approved by council.
But if it is, it will be,
It's a separate situation in my mind. You provided someone a discount. That was it.
So my question in regards to that is how can we do that so we're resolving these issues and we're not taking up committee time to do this?
I would say, I think what you're doing is perfect, and that there's going to be times where it's going to have to come to committee. And I don't hold that against you, you know? I
just
think,
want to make sure that we're consistent then with how we're using that enforcement to gain compliance, so that way when we have a neighbor, when they're asking us.
right,
We want to make sure that we're being consistent with our approach.
right, right. And I think when you feel you need to use a tool to get compliance, you use that tool. And when, according to your discretion, if you think you don't need to use it at this particular moment, put it in your back pocket until you do. And then if it comes to a situation where it does need to come to committee, we can hash that all out. But I think the work you've been doing has been exemplary. I think the way you've been using your tools and providing support, I think bringing NeighborWorks in was just excellent. It kind of reminds me of community policing, where, you know, we have enforcement, but we're a resource and helping people be compliant. So I find no fault with staff at all. I think staff has done exemplary work, and I'm hoping I'm not making your job more difficult. Is what,
So all this,
you know?
can I take us back to Mr. Rome? Because we were talking a lot about the previous case. So $400, we held this to May. So my suggestion is if you want to give her more time, The next meeting is August 14th. But then I would say at that point, my suggestion, if the work isn't done, we deny the appeal for the $400 and permit the inspection staff to start re-inspection fees again. We've given them since January. We have to, the inspection supervisor's point, we need to have a timeline when they can resume doing their compliance work. Because at this moment, we're doing nothing for compliance.
Right. Well, let's make a motion to open the floor. It seems like Ms. Rowe wants to add something. Motion to open the floor.
Second.
All in favor?
Aye.
And Board, I just simply want to state that these cases are different in each sense. In every definition of the word, each case, whether a citizen is cited, it's a different case, it's a different hardship, it's a different scenario. So they've got to be looked upon as case by case. So, Mr. Weeds.
Mr. Pappy.
Yes, Mr. Pappy doesn't look at it like that. He's grouping everything together, and there's differentials. There's different scenarios in each case. Some people want to comply and can't, and some seek help, and and so there's different scenarios, and it's got to be looked upon as that. So.
Yeah. But you do expect to be done this week?
Absolutely.
So August 14th, no issue to come back?
Absolutely no issue.
Okay, motion to close the floor.
Second.
All in favor?
Aye.
Okay, ayes have it. Now closed.
Yeah, and I'm sure staff uses a lot of discretion, but they want to be careful using their discretion because they don't want to be stepping on committee's toes, and they don't want to be, they don't want to be putting their neck out, So I think staff's been doing a great job, my opinion. So my motion is to hold this until our next meeting.
Do I have a second?
Second.
All in favor?
Aye.
Thank you, Board. Have a wonderful, wonderful evening. Thank you.
We'll receive a notice, but please come back on August 14th.
Absolutely. Absolutely. Everyone good.
Ready? Informational only, the release of 3/2022-2023 available Class B liquor and Class B beer license to the pools due to no action taken for the 2023-2024 license year.
Yes, thank you. So it's just an informational item. We had 3 licensees that did not renew for the 23-24 license year. So that means that the beginning of business day after the council meeting, which will be Wednesday, August 2nd, we open at 7:30 a.m. We will take complete applications to the first that file to the first that file. So we'll take up to 3 to the people who provide us with a complete application and are first in time.
Thank you.
Thank you.
Licensing report?
Yes, me again. So just pull that up here one moment, please. So the City of Green Bay has issued 167 of the 172 available Class B combination licenses. We currently do not have any available liquor licenses at this time, but once again, August 2nd at 7:30 a.m. we can begin to take applications.
Thank you.
Are you allowed to tell us the 3 that did not?
Yes, so that would be, we did not receive one for 1238 Main Street. We did not receive one for 1911 University Avenue, that was Lone Star Grill. And then we did not receive one for 1850 University, which was Gippers.
Main Street was sliced on Main.
Thank you.
It's across from, not the building that was in. Across the street.
Liquor violation report?
We have no violations to report.
Thank you. Motion to receive and place on.
Does the lieutenant concur on that?
I concur.
Question.
Yes.
I'd asked you once, I knew there was a big fight at Common Council, that mutual aid was used. Now I heard there was a second one where there was a weapon discharged. Do we get reports on that stuff or not?
Yeah, which, downtown or?
Crown and Common? Or whatever it's called, Crown and...
Crown and Commons. I guess offline or separate, I could definitely tell you, I don't know if you saw in the media, yes, there was a weapons call there, someone was shot out in the parking lot out front. The owner of Crown and Commons called us, and he's agreed to shut down his establishment. I believe it's at midnight every night, and he has worked tremendously with us. We didn't ask this. He's trying to push the clientele that's been showing up. He doesn't want to deal with that anymore. So he has shut down, or he doesn't stay open till the quote bar close. He's shut down by midnight. He talks about this spring this fall. He might open a VIP room where from midnight to 2, it's only people he knows will be allowed in his bar.
That's neat.
Because he doesn't want to deal with that element. We've tried everything. He's worked great with us. He's always given us video. He's switched his hours. He's worked with security staff. There's other things we're working with him on. With all the bars in the area, they kind of have a set standard for every establishment where if you cause problems at one, you're not allowed in any of the others. We can't enforce that. That's up to them to decide between themselves. But there were no actual liquor violations going on at that time.
Glad to hear that you're satisfied.
Yes.
You
The
should
owner
just
probably is right after that happened, he reached out to us almost immediately and had the meeting and made the decision.
Should just recommend he switch to country music. That'll get rid of
That
it.
was brought up to him, and he is seriously thinking of, for about a week straight, change it to Crown and Country. And
I think polka.
Or that.
Motion to receive and place on file.
Second.
All in favor?
Aye. Motion to adjourn it.
Do we have a second?
Second.
All in favor?
Aye.
Any? Ayes have it, we're now adjourned. Thank you.
I had filled out a form to speak earlier, but
Stopped.
Oh.
I wasn't able to speak earlier, so I just came here. And I was working in Waiawega. I'm an occupational therapist at a skilled nursing facility.